Part one of this series, I talked about Kyle's minor possession charge and whether that charge would likely negate his self-defense claim. According to my argument there, and I think it's all pretty reasonable, no. The fact that he was a minor in possession of a handgun or a rifle is not going to have any effect on his right to claim self-defense. There is also another argument I want to offer here. So here it goes. You have Carl and Kyle Rittenhouse. They're brothers, and they're walking down the street together. They both have AR-15s. Kyle is 17. His brother Carl is 18. Now, Kyle doesn't have a real brother. I'm just making this up. And they run across Joseph and Jack Rosenbaum. Now, Joseph Rosenbaum chases after Kyle, and Jack Rosenbaum chases after Carl. So you have the two brothers running, being attacked by ex-felons who are violent lunatics. And everything is identical. They're running, and Carl shoots Jack, and Kyle shoots Joseph. Okay, so here's the deal. Both of them are in identical situations. The only difference is that Carl is a year older than Kyle. Now, the question becomes, does Kyle lose his right to self-defense because he's 17, while Carl retains a right to self-defense because he's 18? There is no way that a U.S. Supreme Court is going to claim that Kyle has to go to prison because he's 17. These two situations are identical, and the only difference between them is the age of the person. If an adult has a right to self-defense in a certain situation, a minor is going to have the same rights as the adult in the same situation. If anything, a minor should have more self-defense rights. Self-defense is a fundamental right, and therefore you cannot deny somebody that fundamental right just on account of their age. So I think that a constitutional argument can wipe out any conviction of Kyle based on this minor possession charge. But let's talk a little bit more about how crimes affect self-defense claims across the country. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
In one of my previous videos, I talked about Kyle Rittenhouse's minor in possession charge. The question was, if he is guilty of minor in possession, and I'm going back and forth with a lot of people on this, and they make really good arguments, no problem with that. I just don't think that the state will see it their way in the end. But if he is guilty of the minor possession charge, does that negate his self-defense claim? Well, if you want to look at what I wrote, or what I stated earlier, check out part one where I went through Wisconsin law. And now I'm going to turn my attention to other laws that exist out there to sort of get an idea about what's going on here. Now, I have tried to find evidence of case law that might settle this, and I haven't been able to find much. However, there does seem to be quite a bit out there about felons in possession of a firearm and their right to self-defense. And so I thought I would take a look at that. One thing that is kind of interesting, in U.S. code here, which, by the way, does not bind Kyle in any way, because after all, Wisconsin has its own laws. It doesn't have to abide U.S. code. But it does mention in here something about juveniles and self-defense. Subsection D, the possession of a handgun or ammunition by a juvenile taken in defense of the juvenile or other persons against an intruder into the residence of the juvenile or a residence in which the juvenile is an invited guest. So U.S. code does provide some protections for juveniles in terms of self-defense. However, that's specific to home invasion type of crimes and such. We won't even worry about it. Now let's take a look at what Georgia says, because Georgia is very interesting in this. Georgia's self-defense laws are codified here using the Find Law database, which is pretty good. And it says here, Georgia Code, Section 16-3-21, use of force. And it says justifiable use of force, and it kind of goes through the stipulations for the state of Georgia, which are interesting themselves. For example, you can use force when you reasonably believe that the force is necessary in order to protect yourself or a third party against another person's imminent use of unlawful force. Well, that's just very similar to typical self-defense laws. Notice also it says that you can use force if you believe. It doesn't matter about the motive of the attacker. The person who is attacking you, he could be attacking you for reasons that he thinks are valid and which could actually be valid. For example, he may be thinking that you're out to commit a horrible crime or something like that, and he may be totally justified in that view. It doesn't make any difference, however. You can use self-defense if you believe that your life is threatened or you face serious bodily injury. Now let's read on. The scope of the force that you can use depends on whether you reasonably believe that the type of force is necessary to defend yourself or a third party. Very typical. Then, you may use deadly force only if you reasonably believe that such force is necessary to prevent death or great bodily harm to you or to another, or to prevent the commission of a forcible felony. It's kind of interesting because Joseph Rosenbaum is, guess what? He's trying to take Kyle's rifle. Joseph Rosenbaum is a felon. He can't possess a rifle, and his possession of a rifle is a felony. So he's trying to commit a felony, and Kyle stops him. However, Kyle didn't know that he was a felon, so I don't think that this would have applied to him anyway. Now, when the use of deadly force is not justified, if you're the initial aggressor, okay, that's pretty common, although that's usually the stipulations are a little bit more abstract than that, but that's okay. You're attempting to commit, or leaving after you have attempted a felony. Now, this is a little different than Wisconsin. In Wisconsin, it basically makes a stipulation that you could lose your right to self-defense if you're committing a crime. In Georgia, it says you will lose your self-defense if you're committing a felony. That's pretty clear. Now, of course, the question is a person who is holding or possessing a firearm in Georgia committing a felony if he's an ex-felon? And the answer to that is yes. Right here, it basically says any person who is prohibited by the code section from possessing a firearm, which would be a felon, because of conviction of a forcible felony, or because of being on probation, blah, 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 shall be guilty of a felony, and upon conviction shall be punished by imprisonment for not less than 1 year, and so on. Therefore, it is very clear. In Georgia, if you are an ex-felon, you cannot possess a firearm, and if you are committing a felony. Also, self-defense law says very clearly here, deadly force is not justified when you are attempting to commit, or leaving after you commit a felony. So therefore, there's no doubt about it. If you are an ex-felon and you have a handgun or a firearm of any sort, and you use that to defend yourself, you cannot claim self-defense. No. My buddies at Ammo Land posted this news item. By the way, I did check the news item out. It comes from the Atlanta Chronicle, I believe, but I did check it. Jury finds Georgia felon has right to self-defense. We should be more careful about how we read statutes. Wasn't so clear-cut after all. And the reason is simple. Self-defense is a fundamental right, and therefore it often doesn't matter what the law says. If your situation is such that your rights are being violated, you can appeal and you might win. Let's take a look at this. So we have here DeMarco Williams shot and killed Javarius Walther. Now, DeMarco Williams, he's a felon. He used, guess what? A sawed-off shotgun to kill Javarius Walther. Now, he can't possess a sawed-off shotgun. Not according to the law. He is committing a felony, and he killed somebody with it. But he claimed self-defense, and guess what? The appeals court upheld his belief that he can defend himself. Now, this is Georgia. But here, Georgia is basically saying that even if you're committing a felony, you can still claim self-defense. Therefore, what are the chances that an appeals court in Wisconsin is going to find that Kyle Rittenhouse cannot defend himself because he committed a misdemeanor? Not much. But it also goes to show you that when it comes to fundamental rights, you have to be careful about reading state law and the fact that state law may be a violation of your rights. And ultimately, it's up to the appeals court to determine that. State law in Wisconsin basically states that you might not be able to claim self-defense if you are in the act of committing a crime. And any time that a person is going to lose their right to self-defense over something like that, there's going to be an appeal to this appeals court, and they may very well overturn it. I don't think that there's any chance that the prosecution's even going to try this. It's ridiculous to claim that Kyle cannot defend himself just because he's underage. So here we have another one. Oklahoma girl shoots home intruder. 12-year-old uses family's gun to protect self and home. And they even have a little video in here from her, and she's kind of cute. She basically kind of grinned and said, "Yeah, I shot him." Okay. A 12-year-old cannot legally possess a rifle in Oklahoma. Therefore, she is violating the law. By the way, she was unsupervised, so don't try that stuff. Her mother wasn't home, so basically her possession of the rifle was illegal. No one's going to seriously suggest that she cannot defend herself just because she is a minor in possession. Okay. A lot of people are also talking about, well, it's the castle doctrine. She's in her home. Yeah, but the castle doctrine only refers to your duty to retreat. It has nothing to do with the age limit of the people. So if you are not allowed to possess a rifle and that negates your self-defense, the castle doctrine's not going to have anything to say about that. The case of Danny Dawkins in Oklahoma is rather interesting. And Danny Dawkins was convicted of murder. He appealed the decision and lost. Ultimately, the state court of appeals basically said that as an ex-felon, he's not allowed to possess a weapon, and his use of that weapon negated his right to self-defense. Now, you might think, well, wait a minute, doesn't that contradict your claim? No. And the reason why is that Oklahoma has an interesting law here. It says, Part D, a person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be, has no duty to retreat, and has the right to stand his or her ground and meet force with force. So what Danny Dawkins was trying to say was that he has a right to stand his ground and therefore should not have been convicted. However, Oklahoma came back, the state said, look, that stands your ground only applies if you are not engaged in an unlawful activity. It does not say that if you are a felon in possession, that you don't have the right to self-defense. What it's saying is that if you are a felon in possession, you have a duty to retreat. He didn't. He stood his ground and killed his attacker, and therefore the state of Oklahoma upheld his conviction. So again, you have to be very careful about how you read these things. You just can't jump to conclusions. You have to really read deeply into it. In my opinion, the prosecution has not a prayer of convicting Kyle Rittenhouse on this basis of minor possession. I mean, they can stick the minor possession charge on him. However, it's not going to have any effect on his self-defense claim. And if you don't believe me, go back and read part 1 where I explain very clearly why I think so. Like my video and subscribe to my channel.